Hi everyone. Today we're going to focus on our friend the Blue Book. All right. So the first thing I want you to do is to learn how to embrace the Blue Book. Now, the Blue Book actually started out as a style manual for law review articles, so it can tend to seem hyper technical. It is widely used and respected not only for law review articles, but for memos, for briefs, or court documents. In terms of organization, the rules of the Blue Book can be found first for practicing attorneys in those Cliff Note pages that I had or will have you guys tab starting on page 3. You have general rules. The white pages or rule of citations, those are general rules for all citations with a little bit more emphasis on law reviews. And then you have the tables, like table T1 that talks about state materials and things of that. Finally, you have help aids, those quick reference or cheat sheets that's on the front flap or cover for law review footnotes and the back flap or cover for court documents and legal memos. The table of contents and the index and quick index are actually very well done in the Blue Book. All right. So for my Tuesday class, this is going to be a refresher, but I think it's important to talk about why citations are important. A citation gives attribution and support. It's a map for your reader. It lets the reader know where the argument came from, and it's a very important expectation for legal readers. It's important that you actually cite, and cite quite a bit. It is not unusual to have lots and lots of citations in a particular document in legal writing. So get used to feeling like you're citing every sentence. That's okay. Here is a picture of a basic case citation. I did it in a table format so you can see all the different parts. Notice you start off with the parties. The party names will always be, in a case, either underlined or italicized, followed by a space and then the reporter volume number, the reporter abbreviation. Here, this is the Federal Reporter, 2nd edition. The first page of the case where you can find that particular case. The jump site, remember the jump site or the pinpoint site actually represents where a particular quote or whatever you're referring to in the case, where you can find that material. The deciding court information, and the date. Here is a sample statute citation. Notice, especially when you're talking about a federal statute, you always begin with the title number. So this number here, the first number, refers to the title number for the statute. This is Title 11 of the USC or United States Code. Section symbol, the section number, and the year the code was published, followed by a period. That's how you do a basic statutory citation. A constitutional citation begins with the abbreviation of the Constitution, the abbreviation of the word amendment, the number, always in Roman numerals. If there's a specific section, then you would do a comma, the section, and obviously you don't do a year. Rules of procedure would just be you abbreviating where the rule came from and putting the number. And you don't have to have a year anytime you're doing rules of procedure. Law review citations will always begin with the author's name, comma. The title of the article typically will be italicized, comma. Space, the volume number for the law review, the actual abbreviation for the law review article, the first page where that article begins, the specific page where the material is quoted or referred to, and the year, the month and the year that it was published, followed by a period. Sorry, I ended up on that other line. A treatise or book citation, almost similar to a law review citation, starts with the author's name, the book title, the specific page, and the year of publication. If you want to cite to the restatement, like the restatement of torts, you would just say restatement, let the reader know which edition of it is, of torts, the section symbol with the section number, and the year. Let's start with a more in-depth look at case citations. So when it comes to case citations, here are the 5 areas where most students struggle. Those areas include improper abbreviations, missing pinpoint or jump sites. Remember, if you're quoting from particular material or if you're talking about the court's holding, you need to let the reader know precisely where they can locate that information. Many students, and that always surprises me, the third one, is forget to include information about the court. You've got to have, in parentheses, the jurisdiction and the year. Short forms are another struggle for some students, and writ history, which is something we're going to talk about in greater detail when we talk about Texas citations, will be the final struggle for many law students. All right, let's revisit our case citation. As I said earlier, always italicize or underline the case name, reporter volume, reporter abbreviation, first page of the case, jump site, deciding court. I want you to notice something about the reporter volume. This comes from the Federal Reporter, 2nd edition. All cases published in the Federal Reporter are Federal Circuit Court decisions. So I know, without knowing much else about the case, that this is going to be a circuit court decision. It's not going to be a trial level decision. I know that because of the book in which the case was published in. If this was a Supreme Court case, I would expect the reporter abbreviation to be U.S. Here, without the graphic, would be a typical case citation. Now, it doesn't matter to me if you decide to use underlining or italicizing. Just pick one. But all case names must have either underline or italicized. Notice the V for versus is lowercase with a period. Notice the spacing, comma, space, you've got the number, space, F second closed up, space at 872, comma, space, 875, space, parentheses, 9th Circuit, 1991, close parentheses, period. Notice Supreme Court cases, you don't have to have jurisdictional information. Also, you may recall that a citation is considered its own sentence. So, Ellison v. Brady ends with ending punctuation, just like any sentence would. If you were writing a sentence prior to giving the citation, it would look like this. You would have your textual sentence, for example, in Meritor, the court ruled in favor of the defendant, period. And then you'd have your citation sentence, which also ends in a period. Make sure you always remember your ending punctuation for both. In terms of typeface, law reviews tend to use small caps, and I wish I had given you a better example on here, but if you go into font, there's always a button where you can flip for small caps, but that's usually made by law reviews. Practitioners, which is what we're studying to become, include ordinary type, underline, and italics. So in terms of typefaces for practitioners, things to keep in mind. Anytime you're talking about case names, you're going to underline or italicize. You also underline or italicize book titles and articles, legislative materials, signals like C or C generally, cross-references like infra or supra, explanatory or procedural phrases like vacated or affirmed. You do not underline or italicize the things in this other column. These things would be in ordinary type: constitutions, statutes, rules of court, admin materials, executive orders, case reporters, services, model codes, or restatements. That's ordinary type. So for example, the Federal Reporter or United States Reporter, that part of the address where I would abbreviate US would not be italicized or underlined. Always, please remember this, underline or italicize the name of the case. I know I've said this a few times, but I'm emphasizing it because it's so important. Now on to some other general rules you need to be familiar with. Anytime you have multiple actions consolidated, you only have to cite to the first action. So, in the case of Jones versus Smith versus Taylor versus Cutler, the case name would actually be Jones versus Smith. You want to omit all parties other than the first listed. So for Mathis and Smith versus Skeena and Cutler, it would just be Mathis versus Skeena. So So we don't need the and part. You just do the first party, skip over to who's suing who, and take the next. All right, I've had a few students do this. They'll put a capital V for versus, or they'll forget the period, or they'll put VS. This is the only appropriate way to do it under the Blue Book. It's a lowercase v with a period. Always place a comma after the case name. Do not underline or italicize a comma. I know you think it's anal, but I do need to tell you these rules because hopefully some of you will, in fact, try out for the law review write-on competition. Reporters. Remember, cases are published in books called reporters. You always want to abbreviate reporter names, and many of those abbreviations can be located under Table T1 of the Blue Book. You need to indicate the volume number of the reporter. Give the first page of the case followed by jump or pinpoint sites. If it's on the first page, you just repeat it. So even though it looks a little weird, under the Blue Book rules, if you were citing Mathis versus Smith and your jump site was 360, you would just repeat it. You'd say 360, comma, 360. There are some common mistakes that some students make when they're citing to reporters. Always remember to check your spacing. Now, this can be quite maddening when it comes to the ICW exercises, I know, but it's important to note still. Federal circuit cases, you need to close up that space. So if it's the F third or the F second, notice there's no space between them. Notice there's no 3 or second. If it's a federal district case, you want to leave a space, like federal supplement has a F period space sup. Okay, let's talk about page numbers. Generally, when it comes to the Blue Book, you need to always do either individual page numbers or a range of page numbers. It's important that you don't send the partner or the judge on this egg hunt where they have no idea where the quote came from. They need to know the specific pages where the information came from. If you have a range of page numbers, then you don't have to put all the numbers again when it's 3 digits or more. You can just drop it to 361-65. If it's non-consecutive, then you would literally just put every page where that particular information occurred on. Now, court information is one of those things that students tend to forget sometimes. Always, and this is the general rule, and there is an exception, but as I have stated in class once before, we're not going to worry about the exception, which is when you're in a particular jurisdiction where the reporter lets you know what the state's in. Generally, you guys are going to either be citing to a regional reporter or federal cases. So I want you instead to focus on the general rule. And the general rule is always include the court and date information. Court and date information be like here, 5th Circuit, Texas Supreme Court, Maryland, Tennessee, what have you. I'm sorry, Middle District of Tennessee, unless it's a Supreme Court case. A Supreme Court case would only have the year. It would never have U.S. 2005. Keep in mind, sometimes Westlaw and Lexis, if you're cutting and pasting your sites, will try to default to this incorrect format. All right. We will do our exercise on full cases later. All right, what do you do when you want to cite a concurring opinion or a dissenting opinion? Can you cite to it? The answer is absolutely. You can cite to a concurring or dissenting opinion, but you have to let the reader know that that's where you're getting the information from. And usually we do that by putting information in what's known as a parenthetical. So information in parentheses, letting the reader know the name of the judge who's either doing the concurrence or the dissent, comma, followed by J. J is not the Judge Battaglia's first name. It actually just stands for judge or justice, and then dissenting, close parentheses. And then you have your whole cite that lets the reader know that you're citing from a dissent of an opinion. In terms of subsequent history, anytime you have a case addressed by a higher court, you need to let the reader know what happened. Sometimes a case may be reversed, or it may even be affirmed, which is great. Here's an example of a case that was reversed. People v. Hawthorne, Here's a regional reporter site with the jump site. It came out of the Michigan Court of Appeals, and then it was reversed later on, looks like by the Michigan Supreme Court. I know that because of my jurisdictional information, looking at Table T1, just putting MICH comes from the Michigan Supreme Court. Mich Court app comes from the Michigan Intermediate Appellate Court. Look at this case that's been affirmed. Same thing. You've got your regular citation. You've got the case name, reporter volume, abbreviation, page number, jump site, jurisdiction. But instead of having a period here, you have a comma and the subsequent history. In this case, it was affirmed. Your subsequent history, just like your case, may be either underlined or italicized. Then you have the information about the case that was subsequent that did something. And here it came from the Arizona Supreme Court. Short form cases are not that hard, but they do take practice. So once a case has been cited in full, subsequent references need to be shortened. Now, here's a question I get all the time, and it goes something like this. Well, Professor, how about I just do the full form of all the cases? Well, you can do that, but I will still take off points because I will assume that you are avoiding the proper short format. So go ahead and follow the rule. You cite it once in full, and everything else needs to be a shortened form. The shortened form can be one of two methods, id or the case name short form. All right, let's start with id. Notice that id is always going to be, just like the case, either italicized or underlined. Notice id, unlike many cases, if you underline it, the period is underlined. And technically, the period is italicized. Now, am I really that anal to care if you got your period italicized? No, but it's just some good trivia to know. You use id if there are no intervening cites. What does that mean? Let's say I've cited a case. Let's go back to Miranda v. Arizona on page 5. And on page 6, I want to cite to the exact same case, and the jump site is the exact same jump site. Nothing has changed, and I didn't cite to anything else between pages 5 and 6. Well, when I cite that second time, since there are no intervening cites, I can just put id. What if I found something from Miranda v. Arizona on page 685? I don't have any intervening cites, but I'm going to a different page. That's when you do id at and the specific page number. The other way you would do a short citation form would be any time you have an intervening cite. So, for example, if you cited to the Smith v. Jones case, and then you cited to Miranda v. Arizona, and so let's say Smith v. Jones is on page 3. Page 3, you also cite to Miranda v. Arizona, and page 4, you want to cite back to Smith. You can't use id because id assumes you're citing to Miranda. To cite back to Smith v. Jones, once you have an intervening cite, would be the first name of the party, in this case Smith, the reporter volume, the reporter abbreviation, the word at, and the jump site, followed by a period. That's it. It should not include the first page of the case. It should not include the jurisdiction of the year. Simply the name of the party, one name usually. It's okay if you want to do Smith v. Jones, you can do that. But usually you just put Smith, reporter number, reporter volume, at, page, period. If you had a really common name like United States v. Jones, well, that's just too common, so you don't want to put United States, comma. You would go with the defendant's name then. Now, every now and then I put this in red. I know it's kind of glary and hard to read, but I put it in red because I get students. Every year there's a student who thinks this is a correct short form site, and I don't know where they get it from. This is just wrong. In fact, it's so wrong I'm not even going to highlight it. I'm just going to say don't do it. That's why it's in red. All right, let's talk about citations and textual sentences. Generally, when it comes to a citation, you abbreviate words in the name of a party. But when it comes to a citation in a textual sentence, we treat it a little differently. Now, keep in mind I am differentiating between a textual sentence and a citation sentence. I'm not talking about, Davis v. Jones, 430 U.S., blah, blah, blah. I'm talking about a sentence that may say something like, in the case of Davis Company versus Jones Incorporated, the court, blah, 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 period. That's my textual sentence where I happen to mention the name of a case. Generally, the Blue Book has these important rules. Number one, the first word in the name of a party in a textual sentence should not be abbreviated. So if the first name was school, I wouldn't abbreviate that in my textual sentence. You only abbreviate in the textual sentences the 8 widely known acronyms: and, association, brothers, company, corporation, incorporated, limited, and number. That's it. Those are the words that you can abbreviate. Any other words need to be spelled out. Another important rule about abbreviations. Generally, if you're talking about case names in a citation sentence, before we talked about in a textual sentence, let me talk about in an actual citation sentence. In a citation sentence, you do want to abbreviate all the case names, including the first words. But United States is not one that you can abbreviate. If the party is the United States or the United States of America, then you actually have to, in your case, say United States versus Jones, then give the address for the case and a period. If it is part of a larger entity like the United States Department of Justice, that is the exception where you get to actually put U.S. Department of Justice. Here's an example of the abbreviation I talked about in a textual sentence versus a citation sentence. Imagine we have a company called Penn Central Transportation Company. Well, and let's say under the Blue Book, if I looked up these words for the name of the case, normally Central and Transportation would be abbreviated for purposes of my citation sentence. But in my textual sentence, I am not permitted to abbreviate any words except those widely known acronyms like company. Remember those Super 8 that we talked about earlier? So Central and Transportation would be spelled out in my textual sentence, but abbreviated in my citation sentence. Another important Blue Book rule, basically, you got to abbreviate all your words in your case names. Look up the words. They're not going to always be intuitive. For example, Mathis versus Agricultural Bankruptcy Commission. I probably wouldn't have thought of abbreviating commission that way or agriculture that way. But through looking it up, that tells me what I need to do. Keep in mind, I would abbreviate this for my citation. If I was talking about the case in a textual sentence, for example, if I was saying something like, Mathis versus Agricultural Bankruptcy Commission is an interesting case, I couldn't abbreviate any of those words because they're not part of those special 8 words outlined in my Blue Book, like company, incorporated, limited, number, and so on. Geographical names are covered under Table 10 of the Blue Book. You want to abbreviate those names unless it's part of a named party. So, Sparling versus Texas Autos would be abbreviated Sparling versus Tex Autos. But if you're talking about the state of Texas, you're talking instead about not abbreviating because it's just Sparling versus Texas. And you already know not to abbreviate United States unless it's part of a larger entity, like U.S. Department of Commerce. You want to omit names and middle initials of people. So Najri I. Mathis versus Keisha L. Smith would be just cited simply as Mathis versus Smith. The exception to this rule if it's part of a corporate entity. If the corporation is actually named the John J. Smith Corporation, then the citation would be John J. Smith Corp. Versus Jones. Anytime a state is a party to a case in that state's court, then you don't have to put the whole name of the state. So anytime, let's say there's a criminal action brought against the peace and dignity of the state, then it would be the state of Texas versus so-and-so. In Texas, as a Texas lawyer submitting court documents in Texas courts, I would say that a case titled the state of Texas versus Oprah Winfrey is really state versus Winfrey. Similarly, if I was a practicing attorney in the Commonwealth of Massachusetts, then it would be the Commonwealth versus Winfrey. Or if I was in another jurisdiction that said the people of New York, then it would be people versus Winfrey. But if you're practicing outside of that jurisdiction, so let's say I actually practice in Florida, and I found this great case, State of Texas versus Oprah Winfrey, as persuasive precedent. I would never say to a Florida case court that the name of the case is State v. Winfrey. Instead, I would spell out Texas v. Winfrey. Or if I had a persuasive case out in Massachusetts, I wouldn't say Commonwealth versus Ann. I would say Massachusetts versus Ann. I hope that was clear. Any questions, make sure to ask me later. Do not include multiple company designations. So if my company is called Mathis Company Limited versus Greenlee Enterprise Incorporated, it's really just Mathis Company versus Greenlee Enterprise. One company designation is sufficient. Certain things can be omitted from a case citation, like procedural phrases. If you're talking about a case and it's the estate of so-and-so, or it's in the matter of blah, 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 or petition of, all you have to do is put the Latin term "in re." That's I-N-R-E. Notice it is italicized. That's a procedural phrase. Descriptive terms, appellee, executor, on behalf of a minor child, you can omit those altogether when you're talking about a case name. Let me touch on parentheticals briefly. Now remember, I mentioned earlier that a parenthetical is information you put in parentheses. There are two types. There's the weight of authority and the explanatory. A parenthetical will always come after the date of the case. See? An explanatory parenthetical will explain something about the case itself. So if I want to summarize what the holding was in this case, but I don't want to go into great detail, after I put the year, close parentheses, I would just put a parenthetical and I would say something about the case. Holding that employer did not discriminate. Close parentheses, my period would be here. Generally, it would be a present participle or gerund phrase, never beginning with a capital letter. That's under the Bluebook rules. If I have a weight of authority parenthetical, that would come before my explanatory parenthetical. So a per curiam opinion, which is a case that's, a really short opinion, doesn't have a known author. I may want the reader to know, this is actually just a short little per curiam opinion. Then I would put that after my general citation. And that is considered a weight of authority parenthetical. Remember, explanatory parentheticals end in ing. They don't have to just summarize a case like holding this. It can be a quoted sentence, but it has to be a brief quoted sentence, a very short statement. For example, if I wanted to highlight all of the constitutional law cases where the court found that the decision was content neutral, I may just list all the cases and just put a parenthetical that says content neutral after each case. Remember, in terms of formatting, you should begin with a lowercase letter and no ending punctuation. In terms of subsequent history, parentheticals should come before subsequent history. Remember, we talked about if a case was vacated or overruled or affirmed, you need to include the subsequent history. But there is an exception. If you're talking about cert being denied, you never have to include that in subsequent history. a lot of people try to get the Supreme Court and they're denying cert all the time. That is not a requirement for subsequent history. Discretionary appeals do not have to be included in subsequent history. Any kind of irrelevant history on remand, rehearing denied, remanded, all that, that doesn't have to be included as well. I'm really looking for something that happened from a higher court where they've done something that can impact the decision. Sometimes case names change on appeal. In that case, you do the new name. But sometimes the parties just reverse. So the plaintiff may become the appellant, for example. So in that case, you don't, really do anything but reverse the names. You generally do not have to talk about prior history either in your citations. All right, let's talk about parallel citations. A parallel citation is basically where you have some jurisdictions decide to publish their own cases, and they'll do it in what they feel is an official reporter. Ohio is known for doing this. So let's say you're looking at Ohio and you'll see a bunch of old books, and there'll be the Ohio reports, and you also see the regional reporter. When it comes to parallel citations, it's important to follow the local rules of the court. Generally, the Blue Book says if you have a document that's going to be filed in federal court or outside the state where the case was decided, then you can always just rely on the regional reporter. You don't have to worry about a parallel citation. If you have to do a parallel citation, then that means you have to list multiple citations. You need to let the reader know everywhere where they can find this case. Generally, that's going to be the official state reporter. So in my example, it would be the Ohio reports, comma, and then the regional reporter. One more thing before I forget, I know I already moved on from the slide about parallel citations. You generally don't have to worry about doing it for Supreme Court cases. And in Texas, we don't have an official reporter anymore, so you're off the hook in that. Let's talk about page numbers for online cases, and I think I tried to do this during your Westlaw and Lexis training. Remember, Westlaw and Lexis use star pagination, including for parallel citations, so sometimes it's confusing to figure out where the jump site actually is. Once you figure out the correct reporter that you're citing to, make sure you see or you count the number of stars or asterisks next to the correct reporter. So when you're looking for your jump or pin site, you go backward until you find that last page where the asterisk is assigned to the reporter you're citing, and make sure you don't switch pages on yourself. So as I stated, the great news about parallel citations, in Texas we use regional reporters. Now when I was in law school, for Supreme Court cases, you had to do the U.S. site, the SCT site, U.S. Law Week site. No more of that. You just use the official reporter, which is the United States reporter. Federal courts, you don't have to worry about parallel citations for that either. You really need to worry more about parallel citations if you plan to practice outside of Texas in a jurisdiction that has an official reporter. All right, this is new. But it hasn't really caught on that much. But there's another citation thing called public domain. So first, let me give you a little background. You may have noticed by now that anytime you're citing to something, it's related to Westlaw or Lexis. Well, there is now a movement in legal research to say, hey, why do we have to pay for access to the law? The law should be free to everyone, all of the people. Why do I have to pay Westlaw or Lexis or any other database to have access to what a judge has said about the Constitution? And since there are some, this is a movement that's starting to gain some traction, people are saying, you know what, we don't like having to rely on Westlaw or Lexis. We want the law to be accessible to everyone. So to make the law accessible to everyone, some jurisdictions, and more each day, are posting their opinions on the internet. Cases may be available on CD-ROM, they may be on the internet. So the question is, how do you cite to that? If you went to a database on the internet, it happens to be the state Supreme Court database, and there you found a great case, how do you cite to it? Well, you need to do what's known as a public domain site. So it looks like this. And the thing that's a little tricky is that because it's on the internet, it doesn't have page numbers. So instead, the authors have superimposed paragraph breaks. So the opinions are broken into paragraphs instead of page numbering in a bound volume. So if you're citing to this Oklahoma case, you would give the case name, the public domain site, which would be the year, postal abbreviation, 54, I guess it's the 54th case, the paragraph where for the jump site, comma, regional reporter, instead of just that case. Table T1 will let you know if there's a public domain site in the jurisdiction that you're looking at. All right, we're going to go a little quick for the last part of this, a statute site. For a statute, you need the title number, abbreviation for the code, section number, year the code was published. So to repeat a statute citation, title number, abbreviation for code, section symbol, number, year, period. And this is what it looks like. Anytime you're citing to statutes, you need to know how to do the section or paragraph, but you never start a sentence with that symbol. If you're starting a sentence, you need to spell out the word section. And you can look in your symbols for your word processing software, and you will find the correct symbol for the section symbol and the paragraph symbol. And there is a space between the section symbol and the number. Finding a year of a statute under the Blue Book. If you're talking about a hard copy of a statute, look at the year on the spine of the volume, the year on the title page, or the last copyright year in that order. If it spans more than 1 year, you just give all the years it was covered. If, however, you found a statute on Westlaw or Lexis, an electronic version, then you're going to have to put information about the publisher in the database. So here I have the Washington Constitution, Article 1, subsection 2, and then I let the reader know this came from Westlaw product. It's current through the 2003 amendments. Excuse me. If you have an amended statute that may be amended in the pocket part if you're using a book, then you would just give that information. So the main volume may be 1997, but the supplement 2003 makes that statute more up to date. Short forms for statute can be a variety of things. It can be id, but you don't use the word at like you would for a case. So for a short form statute, you can just use id and the section. You can also use the section without the title number. So 42 U.S.C. section 1982, designed in 1994, could be 42 U.S.C. section 1982. It could also properly be just section symbol 1982. Secondary sources. Typically, all of your secondary sources will start off with the author's name, title, page or section, and the year. See, book, I've got my author, I got the title, pages, year. My law review article, I got my author, the title of the article, italicized, which law review was published with that special abbreviation under table T6, I believe, the specific pages, and again the year. Don't forget to abbreviate periodicals. You need to always check the Blue Book, table T13, and look up each individual word. You do not have to worry about your articles, like A, B, etc. For model codes and restatements, that's covered under Rule 12.8.5, but this is what the restatement or the model penal code would look like cited. Rules of procedure, you just don't need a date. They're pretty easy. Ordinary type for attorneys. Internet sources. So internet sources, oftentimes some things on the internet are only published on the internet, and some things on the internet are published in book form and the internet. You have to first determine which source you're dealing with. If you're dealing with something that's directly and only on the internet, you just need the author, web page, last visited info. If it's a parallel site, for example, you know this is published elsewhere, but it's also available on the internet, then you would give like the normal citation information, author name, and the title, where it's published, and then say it's available at that internet address. Believe it or not, you can even quote or cite to blogs, because there have been many legal scholars, law professors who write their own blog. One very well known is from Eugene Volokh. He's from UCLA, and he's a constitutional law scholar. And his blog has been cited by more journals than I can count, probably some cases as well. So this gives you information on how to cite to the blog. You need to say who posted it, where it came from, where you visited it.